Hi, this is Rahul Reddy. We are here presenting from REDDY NEUMANN PC. We bring in immigration updates every week on Tuesday at 5 p.m. Central Time. Along with me is my business partner, EB-2.
Thanks for joining us today. As usual, we'll be answering your live questions. So if you have a question, feel free to chat with us on YouTube or Facebook while we're live here, and we'll try to get to as many as we can. If for some reason we're not able to get to your question, you are welcome to join one of our daily conference calls. We have a free conference call every day where you can dial in and ask your immigration questions to one of our attorneys. That information is on our website. If you go to rnlawgroup.com and click conference call, you'll get all the details for that. Today, we're going to be talking about the idea of downgrading from EB-2 to EB-3. We will discuss the resuming of premium processing for all H-1B petition types and what we know so far about the upcoming H-1B cap. We'll also talk about the impacts of upgrading your case to premium processing or filing it in premium processing. There's a lot of rumors about premium processing actually being harder to get approved or more RFEs. So we'll talk to you about those rumors and whether there's any truth to it. And we'll also give you an update regarding F1 students and how to properly maintain your status while you are studying in the United States.
So let's first discuss on the aspects of the downgrading of the EB-2 to EB-3. When does the circumstances come out when people would like to downgrade from EB-2 to EB-3? When the priority dates for EB-3 are more forward than that of the EB-2, that's when the people would like to consider downgrading from EB-2 to EB-3. Now, the EB-3 going forward than that of EB-2 historically did happen many times. It's nothing new. However, for the Indian nationals though, since the time priority date came in, I've been living with this priority date from 1996. That's when the priority date started kicking in. It has never been historically that EB-3 was never more advanced than that of EB-2. Only recently for Indian nationals, we have seen EB-3 advancing, especially for filing the adjustment of status. However, for the Chinese nationals, there were a lot of times where the EB-3 was ahead of EB-2. In circumstances where EB-3 is ahead of EB-2, what are the steps that need to be taken? That's what we are going to discuss, and it's up to you to decide. Now, when the priority date is forward, Emily, and if my priority date is not current, either under EB-2 or under EB-3, can I downgrade it?
You can.
Or should I downgrade it?
You can downgrade it, but there's not really any benefit to doing so because there's a chance that the EB-3 date might not become current for you. And so now you've just spent time and energy and money on a downgrade that you aren't ever going to be able to use. So I think until it's actually current in the EB-3 category, I wouldn't proactively downgrade.
I have a doubt, Emily. What if the priority date of EB-3 has moved forward and my priority date became current and I don't have the labor and I-140 approved? Then won't I lose the chance of filing an adjustment of status?
You don't have the EB-2 labor and
No,
I-140 approved?
I have the EB-2 labor and I-140 approved. I don't have the EB-3 approved. If I don't downgrade it and EB-3 advances, don't I lose the opportunity of filing the adjustment of status?
And you would lose it for that particular month, but if EB-2 later becomes current, you would still have that.
Can't you file? Can you not file I-140 and adjustment of status at the same time?
Right.
Okay. So can you explain that when the EB-3 advances, how can you file without filing labor certification? You can file an I-140 and you can file the adjustment of status. Can you explain the process? Because at no time when the priority date becomes current under EB-3, people are not going to lose the opportunity to file adjustment of status. But I want you to explain how the process works where when the EB-3 is advanced and my date becomes current under EB-3 but not under EB-2, how do I file adjustment of status immediately?
Right. So when your priority date is current, you always have the option, at least right now, of filing the I-140 and I-485 concurrently. So you can file your EB-3 I-140 petition. So that's where you're going to take a copy of your old EB-2 labor certification, file a new I-140 petition, but checking the box for EB-3 instead of EB-2, providing all of the supporting documents all over again. And along with that I-140 filing, because the priority date is current, you also file the I-485 with it.
Emily, you're saying that you don't need to file a labor certification again, and you can file the I-140 and adjustment of status at the same time when the priority date is current to downgrade it. Didn't you told before to your clients, and did all the other immigration lawyers told to the other clients that when you are upgrading from EB-3 to EB-2, you require to file a labor certification again and I-140, and now you're telling you don't need to file a labor certification, it takes time?
Right.
Is it true?
Yeah, that is correct. So a labor certification, the job offer stated on the labor certification is what determines whether the petition can be filed in EB-3 or EB-2. So if a job offer on the labor certification requires less than a master's degree or a bachelor's plus 5 years of experience, it can only be filed in EB-3. That same labor certification does not meet the EB-2 requirement. Sorry. So in order to go from EB-3 to EB-2, you need a new job offer that does meet the EB-2 requirements. The reverse is different because now you have an EB-2 labor certification. The job offer on the labor certification meets the EB-2 requirements, but that also means it meets the EB-3 requirement because the EB-2 requirement is greater than, so it also includes EB-3. So you have the option of using that exact same labor certification. Even though it qualifies for EB-2, you can choose to instead file it in EB-3.
It's just like that. When you are wanting to buy a movie ticket, if the movie ticket costs $15, you have only $10 in your pocket, you have to go get $5. That's where you get the labor certification when you upgrade it. But if you have $15 in the pocket and the movie ticket is only $10, you just pay $10 and get it. So when you're downgrading, you don't require a labor certification, but when you're upgrading, you require a labor certification. So you don't lose any time. You can file the adjustment of status when the priority date is current. So that's the reason why I would not be hurriedly going and downgrading it until my date actually becomes current. Emily, on the premium processing, the immigration has updated. Can you, does anybody can file premium processing right now? Everybody can file premium processing right now.
Yes, every type of H-1B can be filed in premium processing, whether it's a transfer, amendment, extension with change, extension without change, cap exempt, cap subject that's still pending from last year, upgrades, even if you have an RFE, you can upgrade a pending case. Yes.
So even if there's an RFE, what if I file the H-1B and there is no RFE? Can I still upgrade to the premium processing, Emily?
Yes.
Okay. Emily, there is a perception that the premium processing always gets an RFE and always gets a denial. There's a perception. Is that true?
No, definitely not. I think that when it's a weak case, whether you upgrade to premium or file it in regular, you're going to get an RFE, and you could ultimately get a denial if you can't overcome that RFE. It has nothing to do with whether you've upgraded to premium processing or not. I think people have a negative, it gives you a very negative view of premium processing when you've just shelled out an extra $1,400 just to end up with a denial, but it's not the premium processing that causes the RFE or the denial. It's the case itself was probably a weak case, or maybe it was a good case, it just had a bad luck. We see that happen from time to time.
It's always better, most of the time, not always I would say, there are some situations where we don't recommend premium processing, particularly when you're only filing for amendment. Now, however though, in most of the situations we would strongly recommend to get the premium processing, get your case adjudicated as early as possible. Because if your I-94 is valid, especially when you're filing for an extension, when you're filing for amendment plus extension, when you're filing for transfer, if your I-94 is there and you get the transfer or the extension denied, you will have many different options that will be available for you that won't be available if the I-94 has expired. So if you get a decision before the I-90 expires, and if it gets denied, you have a 60-day grace period in most of the scenarios. But if your I-94 expires, it does not give you the 60-day grace period that's there. So we would strongly advise that people should get the decision before the I-94 expires so that they have alternative options in case it gets denied. And as Emily said, that there is no truth whatsoever at all when that the premium processing gets more RFEs and premium processing gets more denial. So don't believe in all those rumors. Emily, there is a lot of issues going on right now. Two of the Cumberland University people who have been deported recently when they're trying to enter into the United States. There's a lot of attention on the student visa at this point of time in the consulates and also those people, CBPs. The ICE has recently raided the University of Farmington students and arrested 136 people, and about 400 people are still in trouble. Isn't it like I get an F1 visa, I'm in the civis system, am I not safe? Do I need to do anything else other than just being in the civis system to maintain the student visa?
Yeah, definitely. So just having the valid civis and the I-20 and the I-94 and your visa stamp doesn't mean you're maintaining F1 status. In order to properly maintain F1 status, you have to be doing the activities that you were granted the F1 visa for, that is studying. So you actually have to physically go to classes and take the required number of credit hours for your level of education in order to maintain your status. And then if you're going to drop below that level, you have to get advance permission from your DSO first. You need to not work without authorization. If you are granted CPT employment authorization, it should be after you've studied for 2 semesters, to where it's more of like a summer internship type of situation. If you are working while classes are in session, generally that should be only 20 hours per week, not full time. Those are the main things that you need to keep in mind in order to not just be active in the civis system, but also properly maintaining your F1 status.
You have cited many rules, Emily. Aren't those rules supposed to be followed by the university, not the students?
Yes, but I would say the University of Farmington was somewhat following or telling students they were following the rules when they really weren't.
Well, I get letters and emails from the universities, my clients show me, that they are following the rules by giving the student visa work permit, and they don't have to go to classes except 3 days in a 6 months period. Do I still need to worry about it, Emily? If out of 1 semester I have to only attend 3 days and the university is saying that I'm completely legal, do I still need to worry about it?
Yeah, I mean, think about it. If you only have to be physically on campus for 3 days, why do you need to be in the United States? You could live in your home country and travel here as a visitor. I'm not saying to do that, but just think of the idea. There's no reason for you to be physically in this country if you only have to attend classes 3 times a semester. That just doesn't make logical sense. And USCIS, ICE, CBP, they all expect you to know the address of your school. I mean, we see people that when we review the transcripts of people who've been expedited removed, that's a fast deportation that happens at the airport typically. When we see the transcript of that, these students couldn't even tell you where the school was located because they've never been there. That tells the officer a lot about how rigorous your education program is, and perhaps that you're not really coming to study and your true purpose is to work.
Maybe you want to go to the question and answers, or?
Sure.
I have a very good question from Ms. Desai. What she says is that how does the cap extension work when I worked on 3 years on H1B and now I am on H4 EAD? You can come back to H1B at any point of time. You can file the change of status from H4 EAD to H1B. You will not be subject to cap. You need to file the change of status from H4 EAD to H1B, and you don't have to file in the first week of April. You can file at any point of time. However, the rule is that until the H1B is approved, you cannot start working on the H1B. However, you can continue working on the H4 EAD even after the H1B has been filed. So you can continue working on H4 EAD if the validity is there, and then convert into H1B. It's many times people do it, not a problem at all.
All right, I have a question about what's the update on the H4 EAD. I just checked with the OMB, and the rule is still pending there, the regulatory review that has to be done before they can actually publish the proposal. So we're still status quo, nothing's changed. We're waiting for them to review the rule before they actually publish the rule. Even after they publish the rule, remember, it's still just a proposal. So the H4 EAD continues, you can still file, they'll still approve them as long as that regulatory process is going on. If there's ever a final rule that actually takes effect that isn't stopped by litigation, only then would your possibility to file be impacted, and that's going to depend on exactly what is in the final rule.
Mohan Babu from YouTube has this question that, are there any risks associated with the EB-2 to EB-3? If you're speaking about the I-140 approval risk, if you're speaking about the adjustment of status approval risk, they're very low, very, very low. If your EB-2 has been approved, there's good chance your EB-3 will be approved. There are more risks associated with the upgrading, very less risk associated with the downgrading. Now, having said that, if you downgrade to EB-3 and you file the adjustment of status, and what if the EB-2 moves forward? That complicates the scenario. It will delay your green card. You would still be in adjustment of status, but it just complicates a little bit. However, having said that, if the chance is there for you when the priority date has become current for you under EB-3, because I come from the immigrant background, I will advise you, take the shot and go for the adjustment of status, because these kind of opportunities don't come that often. The priority date was current in 2007, and then it was backlogged so much, it just moved a little bit in 2012. So for the period of 5 years, it didn't move. From 2012 to right now, 7 years, it did not move forward for EB-2. So those kind of openings come very short. I would like you to take. I want you to wait until I-140 approved before you take any risk. And you can always upgrade into premium processing for the I-140. You can discuss with your lawyer to evaluate, but I would say that you should lean towards filing the adjustment of status, Mr. Mohan Babu.
All right, Ganesh wants to know about the odds of EB-1C I-140 approval right now. We don't have any statistics on I-140 approvals or denials from USCIS. The last time they provided us statistics was all the way back in 2011. So we don't have anything concrete, but I will say, since Buy American, Hire American, the level of scrutiny has definitely increased. They're really looking at, does the position meet the definition of manager or executive, both in the US and abroad, and there's very specific definitions for that. So definitely higher level of scrutiny, so I would assume there's going to be more denials than before in that category under Buy American, Hire American.
Vishnuvardhan from YouTube has this question. His mom came to United States. The passport stamping is only expiring 2 months from now, but when she entered into United States, the I-94 was being given for a period of 6 months. Is it 2 months or is 6 months that she is allowed to stay in the United States? Vishnuvardhan, she is allowed to stay until the I-94 expires. In this case, it's 6 months. Even though the passport visa is expiring in 2 months, it is the I-94 that you rely on. Let's say, so she can stay for 6 months.
Pavan has a question. His I-94 expired. He's got a pending amendment plus extension that just received an RFE, request for evidence. Can he file a transfer in this situation? So yes, technically you can file a transfer. However, it's very likely that your transfer is ultimately going to get approved without an I-94 card. They're not going to give you an extension of stay because at the time of filing your transfer, your I-94 had already been expired, which puts you in what's called a period of authorized stay. That's different than being in H-1B status. So when your extension is pending and your I-94 has not yet expired, you are in H-1B status. Once your I-94 expires, you're continuing to stay based on that pending extension, but you're not in H-1B status at that time. You're now in a period of authorized stay. To file a transfer and to receive the approval of the transfer, you would have to show that you are in status on the day of filing. Since you're only in a period of authorized stay, it's very likely that that transfer is going to be approved, assuming it gets approved without the I-94 card. You'll have to exit the country, get a new visa stamp, and come back in order to get back into H-1B status.
Balakumar has in this good question. His I-140 has been approved for more than 180 days. I'm adding this one, Mr. Balakumaran. It's been approved for more than 180 days, not been withdrawn, and he is out of the country. He completed his 6 years of the H-1B. Can he come back at any time by filing a H-1B, not subject to cap, or does he have to wait for 1 year and file under the new quota? Since your I-140 is approved, Mr. Balakumaran, and even though you have used up your 6 years, you can always come back on the H-1B, not only with the same employer that has the had the H-1B before, not only with the same employer that has the I-140, you can come back on any other company's H-1B using the other company's I-140 approval, assuming that it's not been withdrawn within 180 days after it's been approved. You can come back with any company. There is no time limit when you can come back. There's no time limit when the company can apply. There is no requirement that you have to stay for 1 year of the period outside the country. At any point of time, you can come in.
Jaya on Facebook has a good question. Can we initiate the green card process while on H-4 EAD? Absolutely. Yes. No issues there. Shiv has a question also. His OPT expired last month and he's in his 60-day grace period. The H-1B filed last year is still pending. Can he remain in the U.S. based on the pending H-1B? Yes. Once the 60-day grace period ends, you're in that same situation I just talked about where you're in a period of authorized stay. You're not in status. So if you stay and your H-1B gets denied, the day following the denial, you're immediately out of status and accruing unlawful presence under the August 9th unlawful presence memo. So there's not going to be a way for you to get back into status at that point. If your H-1B is denied, you'll have to exit the country. So yes, you can stay, but just be aware of the potential risk of getting that H-1B denied if you stay beyond 60 days.
Pranay has this question, Emily, I want your attention also. Actually, he doesn't have a question, he wants to have an opinion, which is a guessing game. How many cap cases you are expecting in the master's quota? How many you are expecting in bachelor's quota?
Oh,
if I'm in the master's quota, what is my percentage of chances of getting in? If I'm in the bachelor's quota, what is my percentage of getting in?
I don't know if I have the numbers to be able to separate between masters and bachelors at this moment. I'll have an answer for you next week.
2020.
Yeah.
He's speaking about 2020.
I know.
Yeah.
I think I'll have an answer for you next week.
Really?
We'll have
You're going to guess
a better idea, yeah.
Okay. So Emily, if anybody wants to, you can follow her in the blog called Immigration Girl. There is a certain way we assess based on the feedback that you give, the caseload that we have in our office. we can judge a little bit. We have been pretty, we've been judging a little bit, but don't count on us, okay? We have been judging. So Emily's promised that next week she's going to put on her blog the judgment, what she feels, how many will be there, and there is a difference between last year and this year because the way the quota has been counted this year. If assumingly the amount of cases that have been filed in the master's quota is the same as last year, you will have a better probability of getting into the quota as compared to the last year. We can say that if it's there. Now, it's going to be anybody's guess, but we will have a better idea based on the caseload. Emily will publish it on the Immigration Go.
Praveen has a good question for you. Does the EB-2 I-140 become invalid when you downgrade to EB-3?
No, it doesn't become invalid. It still is valid. You can still use that EB-2. However, though, if you file the adjustment of status and you use the EAD, it will complicate the situation if ever you want to use the EB-2. If you don't file the adjustment of status and you have not used the EAD, yes, you can use that EB-2. It doesn't invalidate by filing the downgrading.
Raghu has a question. His wife is considering changing status from H4 to F1. She previously had an F1 and used her OPT. He wants to know what concerns there might be with that. So if she previously had OPT based on, for example, getting a U.S. master's, she's changing status now to get another U.S. master's, she won't be eligible for more OPT after she graduates. She has to go up a degree level for that.
What a good questions are coming out today, Emily. Subbalakshmi has this question. I am graduating from college on H4 visa. Can I apply from the master's quota of H1B?
Good question.
Yes, you can apply in the master's quota. You don't have, if you have a master's degree from USA from accredited non-profit organization, even if you are in H4, even if you are in India, even wherever you are eligible to apply in the master's quota.
All right, Pavan has a good question. We'll have to look into our crystal ball to answer it. Do we know until when premium processing will stay available? Unfortunately, we have
There's
no
another
idea.
question, Emily. There's another question that I am going to add that I got it from YouTube. Is the premium processing is going to be there for the quota of 2020, which we are going to file in April?
So as of today, based on the announcement, the answer should be yes. However, based on the fact that the last 2 years they've suspended premium processing for cap subject cases, I would be shocked if we don't see an announcement sometime in the next 1 to 2 weeks, again suspending premium processing for cap subject petitions this year. So last year, I'll tell you, that announcement didn't come until March 20th. So that kind of makes sense given our current environment that it'll be a last minute announcement that we won't know until it happens. But my guess, this is totally a guess, that there will not be premium for this year's cap cases. I hope I'm wrong, but just prepare assuming that it won't be available.
Boomil has this question. I'm an OPT, I changed the employer recently. Are you guys still taking the H1B cases for this quota? Yes, we, under limited circumstances, if you would contact us immediately and by tomorrow we can get all the information from your employer and you, yes, we could. I would, maybe in 1 or 2 days we'll close the doors. Right now we are open. Yes, you can contact us immediately though, because we are willing to work overtime, even if it's profitable or not profitable, because we don't want people like you to lose the opportunity that you get once in a lifetime to file a H1B.
Kieran has a question. So his question is, he's got an RFE on his I-140 and hasn't received it yet, wants to know what it could possibly be. I actually have a blog post about that on immigrationgirl.com. There's a little search engine in that site. If you enter an I-140 RFE, you should find an article called The Top 6 Reasons for I-140 RFEs. So that will give you some more insight there. Off the top of my head, typically the issues are Is the beneficiary qualified for the job as it was described on the labor certification? So if the labor certification says the job requires a bachelor's degree plus 5 years of experience, did you submit documentation that you have the equivalent of a U.S. bachelor's degree and 5 years of experience? Sometimes they question the experience letters if they're not detailed enough. Sometimes they will question the company's ability to pay the salary offered, especially if the salary mentioned on the labor certification is higher than what you're currently being paid, so that can be an issue. Those are the main ones off the top of my head, but check out that blog post on immigrationgirl.com for all the others.
Good questions are coming today from the YouTube. Since they're removing the H4 EAD, can I still file for the H4 EAD? Yes, please file for H4 EAD if you are eligible for. What we have noticed the Trump administration did when they removed the EADs for 900,000 people was that they have given a chance to the existing applications to be adjudicated. So we can't say what they're going to do, but if I were you at this point of time, hurry up and file the EAD ASAP. Another question is from YouTube, Emily, is my wife is working as an assistant teacher in a Montessori school. What do you think of on a H4 EAD? What do you think her probability of getting the H1B? But I want to also expand that question more after you answer it, Emily.
I think it would be very likely that you'd get a request for evidence on whether that job is a specialty occupation, whether it normally requires at least a bachelor's degree in a specific field of study. You may have difficulty getting that approved.
Yeah, that's going to be tough. So when, Emily, that also opens up that there are significant amount of denials in 2018 on the H1Bs based on the specialty occupation that you speak about. According to the immigration, 25% of the H1Bs that were filed were being denied last year in 2018. Now, out of those things, seems that significant amount of them were being denied by the specialty occupation. Can you explain what the people need to be careful about when they are picking the specialty occupations and filing the H1B simply?
Yeah, I think a lot of people get confused about specialty occupation and think that, well, as long as I have at least a bachelor's degree in the field that's related to my job, that's enough. It's what I have that counts, and that's not the case. For specialty occupation, it's not even what does your specific job require, it's bigger picture. What does the industry normally require for that type of job? And it has to be that the industry standard is a bachelor's degree or higher in a specific field of study. Must be normal for someone to get that job and move into that occupation. Now, how do you know what your job normally requires? It's not enough to just look at what your company says the job requires. You have to figure out what occupation code the job falls under. It's called an SOC code. You can do some research on that by going to ONET. That's the Department of Labor's overview of all the different occupations and what the typical job duties are for those occupations. Once you've found the occupation code that most closely matches the job duties of your position, the next place you want to look is the Occupational Outlook Handbook. This is also issued by the Labor Department. For each of those occupation codes, or at least almost all of them, it will spell out how to become that job. There's a little tab that you click how to become one, and it will have a little introductory paragraph that says, this position normally requires a bachelor's degree in X field of study. That's what you want to see. Nothing more, nothing less. That gives you a good indication that the job is a specialty occupation. Now, if it says some employers require a bachelor's degree, but some do not, that suggests that some people can get that job at a lower degree, and therefore it's not a specialty occupation. You also have to look out for entries that say many employers will accept a bachelor's degree in business administration, mathematics, financial accounting, statistics, economics, or other related fields. When you start seeing a list of multiple fields of study, that suggests to USCIS that there's not a specific field of study that's required, and many different fields of study can qualify for the job. So there's a lot of positions and occupations in the Occupation Outlook Handbook that have language that causes specialty occupation RFEs. Now, even if you get one of these types of RFEs, it's not necessarily mean the petition is going to be denied. They're going to be looking for, number one, a detailed job description. It can't be vague. They stress that so many times in different RFEs. It's not enough to say a software developer develops software. You have to give the step-by-step of every little thing that that software developer does in the grand scheme of what the company is doing as well. Then they're going to ask you to look at, okay, what does the industry require? That's where they rely on the Occupational Outlook Handbook. So if you have another credible source that says that these jobs normally require a bachelor's degree in a field of study, then you can cite to those. They're also going to look at what does this particular position require. They'll look at what are your past job vacancy announcements that have been used for that position. They'll look at other employers' job vacancy announcements. And then if there's anything special or unique or complex about this particular job, and that's where kind of the wage level can come into play. If it's a level 1 wage, that may suggest that maybe it's not very complex or special or unique to require a degree. So all of those things are going to be looked at when determining whether the job is a specialty occupation.
One question is that in the 485 application interview, the officer said, everything is fine, I'm going to approve it, I'm going to let you know how long it's going to take for the person to get the green card. Typically, once they say their word, it normally takes about 2 weeks, 3 weeks for the security background check up if there is anything else before they can. But if it's taking longer than 2 or 3 weeks, I would wait for 1 month and raise a service request online to get the attention of the officer to adjudicate that case. Typically, 2 weeks is a time that will take. One question, Charles asks this question, can a person who entered without inspection can file the adjustment of status? The answer is simply no. You cannot file the adjustment of status if the person enters without inspection. There are some exceptions available for those people who were present here in December of 2000 and they have filed a green card application either to family or employment based before April 30th of 2001. There is very limited exceptions. They have to check with their lawyer if they are eligible for it. But I would say no to say no for 99.9% of the people. The answer is no.
I've mentioned possible litigation about the H4 EAD proposed rule a number of times, and so Pratyusha has a question. What are the possibilities for a potential lawsuit if DHS goes through with this revocation or rescinding the H4 EAD rule? The process they're going through right now is very similar to DACA and TPS and the International Entrepreneur Advanced Parole that they tried to do. All of those have been saved by litigation. So what typically you're looking at is, did the government act arbitrarily or capriciously in deciding to do the action that they're doing? So meaning that if they don't have a good reason of why 3-4 years ago they said that we need this H4 EAD and now they've done a 180 and now we don't, and they can't justify that, that is a reason to file a lawsuit on it. Or if it's something that is against the Constitution or a violation of the Administrative Procedures Act, all of those different things, or maybe there's some racial reason why they're rescinding it. You know, we know that it's majority women, majority Indians that receive this EAD. Maybe that could be a reason to file a lawsuit.
That's what happened in DACA, because it was more Spanish kids who were in the DACA, and the Trump administration, according to the arguments which the Ninth Circuit Court, what he said is that the Trump administration has discriminated based on the Spanish people. That's the reason why they have allowed it. So in this case, in the H4 EAD, we could use that too. We have a good chance of winning. So Emily has already done all the survey. About 10,000 people have participated in the survey. She has already collected the data. We are all set, ready but we're waiting when, hopefully so we don't have to file the case, but if we have to, we will file the litigation on the H-4EAD.
Aaron from Facebook has a question. Is it possible that USCIS actually schedules the green card interview appointment before the EAD has been issued? Yes, there's no requirement that one has to happen before the other. If the EAD gets delayed, or we're seeing longer and longer processing times for that, and an interview spot opens up, they'll go ahead and schedule the interview.
Yeah, I've seen some of the cases where they try, instead of approving them the EAD advance parole, they just approve the green card, and that's the end of the story. That's nice, if it happens, and but we used to see that a lot, especially in 2016 and 2017. Very rarely right now, but yes, it could be possible. A very good follow-up question, Hemchand. We assume sometimes when we answer Emily, we assume that clients knows. It's a very good question. What the question is that on the H-4EAD, if the I-140 has been approved, can they get back to H-1B if they had a H-1B?
With their own I-140 approval?
Yes.
Yeah, absolutely.
Yeah,
great
absolutely.
Question. Especially even if you've already used up your 6 years of H-1, you can absolutely.
Yes, that's the only reason why you're filing an I-140 to get back. In that you already have your spouse I-140 to get in. Yes, you can get back to H-1B even if you use the I-1, even if you used, even if you have used the 6 years. One other question, not a good question, but yeah, people are curious. This comes in. He has a EB-2 I-140 approval. His wife is filing an EB-1. Can she port the date of him to her? No, she can't port the date. She can only port her date into her EB-1. Since it's yours, she cannot port into her EB-1.
Venkat has a good question on Facebook. Is it possible for an H-4 to study full-time master's without changing status to F-1? Absolutely. Assuming this is an H-4 spouse where you're not talking about a child who's reaching 21 is going to age out of H-4, but definitely an H-4 spouse can attend school and graduate with a master's degree without ever changing to F-1 status. I see a lot of questions, especially on my blog or in consultations, of people who are in H-4 status and studying and switching to F-1 for schools with day one CPT so they can work. And please don't do that. The purpose of the F-1 is to study. It's not to get employment authorization. You can study in H-4. There's no reason to go that risky route.
I've never seen more better questions than today. Chris has this question. I am an H-1B in this country for 10 years. Can I be the owner of the S corporation? It's a good question. Will that cause any problem for me at a later date? It's a complex question to answer, though it's a good question that you need to know. There is a difference between the ownership and there is a difference between the being a part of the company, working in the company. For example, simple, and you pointed out S corporation, so I want to be very careful on it, but I want to differentiate first. Let's say, for example, you're going to buy a stock in Microsoft or Apple. You are the owner of the Microsoft or Apple. And there's no restriction on H-1Bs that they can't be the owner of the Microsoft or Apple. But when you work for the company, you would require a H-1B to work for a Microsoft or Apple. You just cannot go and work because you are an H-1B. You just cannot go and work. Now, when it comes to the S corporation, these are small corporations. We want to be very careful on the involvement of the person who is owning. If it's a restaurant, yeah, you will own the company. Will you go to the restaurant? If you go to the restaurant, are you just eating and paying the money and coming back? Are you doing something else? So that gray area, I want to be very careful on. I have noticed a lot of difficulties recently where the people's H-1Bs got denied. When they went to the consulate, their H-1B got denied. The green card interviews got into trouble because they were owned. They were partners in the S corporation. Now, if there is no involvement whatsoever at all, and just the owner, maybe you would not be in trouble. But I would sit down with a lawyer, evaluate it very carefully, because every time when I speak with the clients, they will say that Oh, I'm going to just visit that restaurant that I own. Why are you visiting that restaurant? Are you eating and paying the money there? I want to just go take a look at it. Are you going to take a look at it? Are you going to look into the quality of the food and comment over that in a purpose so that they can change it, not as a customer? So the gray line is very tough. I would recommend depends on the line of the business to stay away from most of it. There are some things where you can involve, but I would recommend that you consult a lawyer.
Anjani has a question. Can I apply for a PhD? I'm currently on my STEM OPT, but my visa stamp has expired. Is that going to be a problem? No, that's not a problem at all. So this gives us a good way to explain about visa stamps, because there's a lot of confusion we find. What happens when my visa stamp expires? Am I okay if I'm still in the US? The visa stamp that's in your passport is what gets you in the door to the United States. You only need it when you're entering. Once you're here, it's your I-94 that tells you how long you can stay. So as long as you have a valid I-94 and you're maintaining your status, even if your visa stamp expires, that's okay. The only time you need to get a new visa stamp is if you need to travel again so that you can come back again after your trip. So once you're here, as long as you're maintaining status, your I-94 is still valid. It's okay if your visa stamp that's in your passport has expired.
Harish asked this good question. Is there a format where he can get it for a non-availability certificate for the birth? And this is required mostly for filing the adjustment of status. Yes, there is a format. You can search it. I don't have my birth certificate rnlawgroup.com, and it will pull out a sample of the non-availability certificate. Not only it has the non-availability certificate, it does as a sample affidavit formats and other documents that may be required for you to fulfill when you don't have a birth certificate. We at Reddy Neumann PC always like to be very practical to the clients. We want to give help to the clients where they can do it and search and do it by themselves, and that is there. Search by I don't have birth certificate rnlawgroup.com in Google. You will get it, and you can get that format, all the details, the format of non-availability certificate, the format of affidavits, the alternative documents that you may be required are all available at rnlawgroup.com.
Rashab wants to know, his wife has spent, I'm assuming he means 2.5 years, it says 2.5 hours on H-1B.
Yeah, I saw this.
And wants to know if she moves to H-4, how do you switch back to H-1B? I apologize, I'm still getting over my same cold from last week. So you're at that point, if you've already held H-1B status in the past and have not reached your 6-year limit, you would file a change of status from H-4 to H-1B, not subject to the cap because you've been previously counted. As of right now, that can be filed in premium processing, but be aware if you don't have an H-4 EAD, you can't start work until the change of status is actually approved. You can't start based on the receipt when you're changing status from H-4 to H-1B.
Shravan has this question. He's been in here on H-1B for 10 years. Of course, I'm assuming that you already have an I-140 approval. Will he has any problem in going back and coming back at any point of time, and will he be subject to the cap? No, you will not be subject to the cap because you have the I-140 approval. You have been counted towards the H-1B number. You can go and come back at any time, Shravan.
Naveen has a question. If he can port the priority date from a national interest waiver I-140
EB-2
to a regular EB-2 or EB-3 I-140 filed by a regular for-profit employer. Yeah, there should not be any issues with that at all.
Jay Prakash has this question. I want to change to a different client and now my pay scale will go down. Will that pay scale by itself is going to cause any problem? Absolutely, that by itself is not going to be any problem. Just because you're getting paid high and now you're getting paid low doesn't by itself create a problem. Yeah, you may want to consider with regards to the levels of the salaries, if it's going to meet the specialty occupation, that's the only concern, but just because you're getting paid less doesn't mean that it's the President of the United States took a lesser paying job than what he was as a CEO of the Trump organization. So yeah, people do go to the lesser jobs. That's normal.
All right, I think we have time for one last question, so I'll take this one from Pavan. He's been doing Dropbox for visa stamping in the past and wants to know if it's still available or if anything has changed. So yes, Dropbox is still available. If you meet the requirements for it, you can still do that. Be aware that even if you're eligible for Dropbox, sometimes the consulate can still call you in for an interview, just depending on the situation with your employment, who your employer is, what type of job you're doing, whether you're third-party placement, whether they need to look at an end client letter or things like that. So yes, Dropbox is still available, but even if you're eligible, they still may call you in for an interview, and we are seeing that more often these days. So I think that's it for today. Thank you for joining us. If we didn't get to your question or you want a more thorough discussion with one of our attorneys, you can always set up a consultation with us by going to rnlawgroup.com and clicking on the consultation button. There you'll see all of our attorneys and all of our schedules will be available, so you can pick a convenient time for you. And as usual, we'll be back again on Tuesday, and I will try to have my prediction ready.
Everybody's waiting. A lot of questions on that, Emily.
Are we going to make a bet on it